Kia ora, I'm George and I'm the Strategic Advisor at Women's Health Action Trust. The current criminal legislation governing abortion in Aotearoa has been associated with a wide range of challenges for how abortion services are provided and accessed. The state of our abortion laws have been associated with delays with the timeliness with which abortion is happening, meaning that by the time people seeking abortions have jumped through the required hoops of legislation, abortions are performed later than they need to be, and we know that the later an abortion is performed, the higher the risk of morbidity for the person receiving the abortion. The state of our abortion laws have also limited access to abortion services. The requirement that abortions take place on licensed premises, which is in our current legislation, means that there's limitations on who can provide abortion services, and that abortion services have tended to be concentrated in urban areas, disadvantaging people in smaller towns and rural areas in Aotearoa. We also know that the legislation around abortion as it has been has restricted innovations around the choice of abortion method. So for countries with reformed abortion laws, we know that there's a much higher uptake of medical abortions, which can be done closer to home and with less medical intervention. And so most of the abortions happening in New Zealand are still concentrated on surgical abortions that need to be performed in hospital units. So we can see that there's been this whole set of barriers put in place by the state of our abortion laws, restricting an efficient, safe and accessible, innovative abortion service provision in Aotearoa. So Women's Health Action has been strongly advocating for a number of years for a revision of our abortion laws and a move to remove abortion from criminal legislation and to place it with health legislation and health regulations where it belongs. The incoming government expressed a commitment to that, and Health Minister Andrew Little requested that the Law Commission review our current abortion laws. The Law Commission's report, as I said, came out at the end of October, and we really welcome the work of the Law Commission report. And what I'm going to do is just give you a brief summary of some of the options that the Law Commission have proposed in terms of the reform of our laws, and then we'll talk just briefly about where Women's Health Action sits in relation to those options. So the three options or the models that the Law Commission has come back with in their report. The first one, Model A, would provide a context in which there would be no statutory test that had to be satisfied before an abortion could be performed. And that would mean that the decision on whether to have an abortion would be made between a woman in consultation, a woman or a person with uterus in consultation with the health practitioner, as all of our other health services are provided in consultation between a patient and a health provider. Model B would leave in place a statutory test that would need to be satisfied before an abortion could be performed, but the test would be in health legislation rather than the Crimes Act. And so the statutory test would be that the health practitioner who intends to perform the abortion would need to reasonably believe that abortion is appropriate in the circumstances, having regard to the woman's physical and mental health and well-being. So essentially, Model B would be a version of the status quo. So in our current abortion laws, 2 certifying consultants or specially empowered doctors who are registered with the Abortion Supervisory Council have to approve an abortion on the grounds that it meets one of the very limited criteria for an abortion as provided for in the Crimes Act, and one of those is that the mental health of the woman seeking the abortion would be compromised by being denied access to that abortion. Model B would be a version of that. Obviously, it would provide for a single health practitioner rather than 2 certifying consultants to be satisfied that the abortion was warranted. Model C would be a combination of Model A and Model B, and arguably you could say something of a compromise between those 2 positions. So Model C says that for pregnancies not more than 22 weeks gestation, Model A would apply. So for pregnancies up to and not more than 22 weeks gestation, there would be no statutory test that had to be satisfied before an abortion could be performed, and the decision whether or not to have an abortion would be made by a woman in consultation with her health practitioner. However, for pregnancies for more than 22 weeks gestation, Model B would apply, where the same statutory test as in Model B would need to be satisfied. Just to recap, Model A is complete decriminalisation. It returns the decision for an abortion to the person seeking the abortion in consultation with her health practitioner. Model B leaves the ultimate decision-making power over whether a person can access abortion with the health provider. And Model C distinguishes between those pregnancies earlier than 22 weeks versus those beyond 22 weeks. So before 22 weeks, the decision lies with the person seeking the abortion in consultation with the health practitioner, and after 22 weeks, the decision rests with the health practitioner. So these are the three models that the Law Commission has proposed to the Minister of Justice to consider in terms of progressing abortion law reform. Now, what we'll see in the new year is a lot of debate happening around those models. And I think it's really important we're debating these issues, that we're very wary about the potential for myths and misrepresentations to take place, and that ideally New Zealand follows both international best practice, best evidence, and the precedents established in international human rights law. And I think if we look across those three things, if we look at evidence particularly around how abortion services can be best provided so that they're safe, accessible and equitable, and when we look at the multiple challenges set down in international human rights law, and when we look at other jurisdictions who have already progressive law reform, Model A is certainly the model that we would be supporting. And we believe that best evidence, international human rights precedent and practice in other jurisdictions supports Model A is that it really simplifies and the whole pathway into accessing an abortion, and it doesn't remove protections and ethical requirements, because of course the doctors who are providing, the health practitioners providing abortion, are still bound by their own codes of professional ethics and standards. There would still be standard health service provision governing abortion, and women would engage with their practitioners around those decisions, but it would remove the unnecessary barriers that slow down access to abortion and that limit innovative and quality services. It would also remove the stigma and shame of abortion and the paternalism that surrounds abortion, because we believe that women are the experts in their lives and that they are best placed to make the decisions around continuing or not a pregnancy. So we'll be continuing to see abortion being a hot topic in the new year, and we will continue to provide some analysis and to be contributing to the debate in the new year. So watch this space, we'll have plenty more to say.